Wish you happy Republic Day to all. I am Keshav Rauti, Medical Record Officer Gested, Health and Family Welfare Department, Government of Karnataka, currently working at SDC, TRC and RGICD Hospital, Bangalore 29. On the occasion of 75th Republic Day, I am remembering all freedom fighters and I am remembering those who are worked in the field of medical records like Mrs. Edna K. Affman, Mr. Mac Gibboni, Mr. Govardhan Das Mowgli, he is the father of medical records, Mr. S.S. Jolly, Mr. Gajiraj, Mr. Sanveer Bhadrappa D, Mr. Eben Jairoy, Mr. D.M. Joseph, Mr. Jaikar Selvarayan, Mr. Jagannathan, Mr. Ramanand Bhatt, Lakshmi Devi Madam, and Mallika Kodandaraman, etc. Finally, I am suggesting to all medical record associations to form the Medical Record Council. It is very useful to our medical record fraternity in the field of medical records growth. Thank you. Thank you. In the occasion, I am discussing about medico-legal issues in medical records. Medical record is the measure through which the issues legal medical research are evaluated at the later date, maybe after years in occasional cases. Whatever is written in the records is likely to be microscopically viewed through eagle-eyed attorneys. Categories of medical records. Certain records must be given to the patient as the matter of right. Example, discharge summary, referral notes, death summary, LAMA cases, etc. Certain records may be issued after the patient or authorized attendant fulfill the due requirements as stipulated by a hospital. It is necessarily that the hospital bills are cleared and the necessary processing fee has been paid. Certain records cannot be given to patients without the direction of the court. Example, OPD file, IPD file, files of medico-legal cases, etc. MCI guidelines, that is the National Medical Council guidelines of medical records. Maintain IPD records for 3 years from the commencement of statement. S 1.3.1. A request for medical records should be acknowledged and document issued within 72 hours. S 1.3.2. Maintain registers of certificates with the identification marks and his signature. S 1.3.3. Effort should be made to computerized medical records for quick retrieval. S 1.3.4. How long should be medical records preserved? There are no definite guidelines in India regarding this. The hospital follow their own pattern as per the Limitations Act 1963 as S24A of CPA 1986. It is advisable to maintain records for 2 years for OPD and 3 years for IPD. However, there is a provision for condoning the delay in CPA. MCA also insists on the preserving IPD records for 3 years in medico-legal cases should be maintained until the final disposal of the case, even through only a complaint or notice is received. As per the PC and PNDT Act, documents have to be maintained for a period of 2 years or until the disposal of the proceedings. As per the DGHS, Director General Health Services, records should be maintained for IPD 10 years, OPD for 5 years, MLC for 10 years. And as per the IT rules, Income Tax Rules 1962, doctors in private practice are required to preserve the daily case register as per Form 3C for period of 6 years from the end of the relevant assessment year. Ownership of the medical records. By and large, medical records are the property of the hospital and it is the responsibility of the hospitals to maintain it properly. Summoning medical records by courts. Medical records are acceptable as evidence as per the Indian Evidence Act 1972 amended in 1961 in a court of law. Medical records that are written after the discharge or death of the patient do not have any legal value. Erasing of entries is not permitted and is questionable in the court. In the event of correction, the entire line should be scored and rewritten with the date and time. Criminal cases, RTA cases, labor courts, insurance claims, medical negligence cases, these all are the medical legal cases. Then now privacy and confidentiality. Privacy is a broader concept with the respect of personal private information. Advocates for the patient privacy hold that the access of medical information should be only through informed consent of the patient and the raise concern over the need to circulate the health care information beyond the healthcare provider. Confidentiality implies somewhat narrow right as it is primarily rooted in the patient medical records. Disclosure of information must be limited on only that which is necessary and to be directed by individual circumstances. The general approach is the autonomy must yield under circumstances where rights and interest of the other are affected. It has ironically been remarked, your rights end where my nose begins. Alternation of records. The healthcare provider should never expunge or obliterate any material in the record. Falsification, fabrication of records to push up things, scratching out the records or inserting addenda between other notes is readily identifiable and may invite punishment under S 193 of IPC or deletion of name for the MCI register under the regulation 7.7. The dictum, if you did not write it down, it did not happen, is liable to be invoked in a legal sense. Judicial decisions in India on issues of medical records. The hospital and doctor were guilty deficiency in service as case records were not produced before the court to refute the allegation of the lack of standard care. The plea of destroying the case sheet as per the general practice of the hospital appeared to the court as an attempt to suppress certain facts that are likely to be revealed from the case sheet. Not producing the medical records to the patient prevents the complainant from seeking an expert opinion. Failure to deliver the X-ray films is deficient. The hospital was held vicariously liable for the negligent action of the doctor on the basis of the bill showing the professional fees of the doctor and the discharge certificate under the letterhead of the hospital signed by the doctor. Not maintaining confidentiality of patient information can be an issue of medical negligence. Cases. Dr. Kunal Saha versus Dr. Sukumar Mukherjee and others. Deficiencies in service was upheld in the view of erratic medication and poor records at the AMRA hospital. Second, the medical superintendent of Gregorius Mission Hospital, Kerala versus Jesse. Patient committed suicide as per the records. Patient wife was allowed to be with the patient only during visiting hours and the instructions asking the wife to be with the husband all the time and shown by the hospital as per the part of the records was clearly manipulated and inserted after the filing of the complaint before the consumer court. In fact, the court of the ink was different from the rest of the instructions and comparison Compensation of 2.75 lakhs along with the interest was awarded to the patient's wife by the hospital. Jagajivan and another versus PGMH Chandigarh records were not maintained properly. Next, Predicant versus Sam and D Limited. Patient was asthmatic and consultant doctor who wrote antibiotic which was misread by the pharmacy and gave the antibiotic tablets which lead the hypoglycemia and irreparable brain damage. The court held that 75% liability was on the pharmacist and 25% of the doctor. EPP Ismail versus Radha NCRDC held that hospital vicariously liable for the negligence action of the court doctor and other basis of the bill showing the professional fees of the doctor and the discharge certificate under the letterhead of the hospital signed by the doctor. Private hospitals must provide medical records as under RTI, CIC slams Fortis Hospital for denying information to a victim of medical negligence. CIC said that license to practice medicine will not become license to kill and extort. Obligation on hospitals to provide copy of the case records to the patient. Dr. Shyam Kumar versus Ramesh Bhai, NCRD said complaint needs medical records for expert opinion. Another one is Rajappa versus the Chaitanya Tirunal Institute of Medical Science, Kerala. So this is the today we talked about medical legal cases, issues, etc. Kindly subscribe and like this. Jai Hind. Namaste.